Rock Hill, SC, a 17-year-old accused of setting the fire that killed his 14-month-old brother, collapsed in a courtroom here as a prosecutor described his alleged actions. Jacob Morgan, charged with arson and murder, was attending a probable cause hearing when the prosecution presented its case, claiming he intentionally and maliciously set the fatal blaze. The prosecutor detailed a deliberate chain of events. A fire started in a bedroom where the infant was sleeping, followed by a second fire in the living room. Investigators testified that a distinct burn pattern suggested an accelerant, such as alcohol, was used. The prosecution argued that Morgan's alleged failure to extinguish the fire, call for help, or save the child, and his subsequent decision to start a second fire, demonstrated malicious intent, the legal standard for a murder charge. In court, as the prosecutor described the events, Morgan was visibly emotional, at times crying and covering his face. When the judge ruled that there was probable cause to proceed with the murder and arson charges, Morgan collapsed to the floor in tears, requiring bailiffs to help him to his feet. Morgan's defense attorney questioned the validity of his confession, suggesting that his client, who is reportedly autistic and has learning disabilities, may have been intimidated during questioning. The family has also defended Morgan, with his mother claiming he was intimidated by police and his stepfather stating, "If I believed for an instant that he could kill his brother, I wouldn't be here." Despite the defense's arguments and the family's support, the court determined the evidence was sufficient to move forward with the charges. Morgan's case now proceeds to a higher court, where he will face trial for the death of his younger brother.
The malice that it would take to set a fire in the bedroom where the child is in the crib sleeping. A burn pattern that goes from underneath that child towards the door of the bedroom that is caused by likely something. It's a significant burn pattern as he described it. It could have been alcohol, it could have been something else that gets consumed by the fire, but a significant burn pattern shows that there is something said significant and intentional. And at that point, to start a fire in that room is hidden, and to walk away, not trying to extinguish that fire, and immediately starting another fire in the living room, and then to claim it's an accident, that it got out of control, that's an extreme recklessness, and that's intent, that's maliciousness, that's a definition of malice. And as you walk away from a fire that you've just lit in another room with a small baby, walk into the front room, light that fire, and then leave the residence standing outside watching it burn till it becomes too much to go back to. That's malice. And so malice is here in both counts, because all that murder requires is malice of forethought and more fascination with fire, to watch that burn, knowing that that child was in there that was going to die, and not calling 911, not saving that child when he could have, and not having started the fires in the first place. He has to take responsibility. And so there's much more here than probable cause. So I would ask the court to find probable cause on both charges in this case.
All right. Thank you, Mr. Thompson. The testimony, listening to both sides, question testimony. I believe the state has, in fact, met their burden. So therefore, I am going to find that there is probable cause to charge the individual with the found over for General Sessions Court for both charges.
If you found this information helpful, please subscribe to our channel and comment below with your thoughts.